Good morning. Today, an important judgment I would like to discuss with you because apart from the subject is relating to foreigners. First, I will mention the citation AAR 2023 Rajasthan 57. AAR 2023 Rajasthan 57 Abdul Wahid versus Union of India. Oh, I am sorry. Oh. AAR 2023 Rajasthan 59. AAR 2023 Rajasthan 59 Khalid Ahmad Gilan Amran versus State of Rajasthan. Khalid Ahmad Gilan Amran, State of Rajasthan. Before that, this relating to foreigner who is overstaying in India. Before that, I want to draw your kind attention that the fundamental rights commencing from Part 3 of the Constitution of India, from Article 12 to 32, guarantees fundamental rights in two categories. One, fundamental right to citizens, and another one is a human rights to any person. So here the foreigner have got right to apply for his rights. Therefore, he files a single writ. What had happened? Actually, he seems to have obtained a visa and stayed in India to pursue his undergraduate. Thereafter, he extended his visa to pursue his postgraduate. Unfortunately, the college in which he joined is not approved one. Therefore, he shifted to another college, and subsequently that college also denied his permission. The authorities, since he is overstaying, they want to apply for online exist visa. He challenged that by a single bench, and division bench has held it that he is not entitled, and that is different. But before that, this is most important. For that only I want to take your attention. So what is principle of natural justice? Adi altam partam. Adi altam partam means whenever any authority passes an order against any person, an opportunity should be given. Here, by this judgment, the Rajasthan Division Bench has denied that Adi altam partam should not be extended mechanically. Therefore, they referred 1955 Supreme Court judgment Hans Muller of Nuremberg versus Superintendent Presidency Jail, Calcutta. They say they have got right a foreigner to expel from this land. That was the first judgment. Then they say Louis de Radet was Union of India, 1991, SC 1886. Again, the government has unrestricted right to expel a foreigner. That opportunity, that this is most important, the opportunity of hearing in such matter is not a hard and fast rule, and where opportunity of hearing would not result in the change of opinion. Non-affording of opportunity of hearing could not vitiate the order. Therefore, the denial of principle of natural justice has been approved here. What that has to be, according to me, revisited, because they say would not result in the change of opinion. How you can change his opinion? Then again they say Isaac Isanga Musamba versus State of Maharashtra. They say a person used in article is wide enough to cover foreign nationals as well as. Then again, this Aija Rao, Assistant Collector of Customs versus Bubuji Bhushan Bagh, AR 1918 and SC 1884. They say where right of person was adversely affected by an order passed by authority, he is entitled to pre-decisional notice or even to post-decisional hearing depending upon the facts of the case. Therefore, they say this right cannot be permitted to be exercised in a vacuum, and where the result despite hearing would be the same. So this is what they have held. So by applying this scale, the judges may dispose your applications, your writ petitions, citing this judgment that the principle of natural justice not hearing you before passing an order, whether what would happen or not. So this judgment has to be carefully looked into. Keep in your mind, my dear friends, because this is most important judgment. Just now I have gone through the judgment wherein being as a foreign national, or this judgment may be extended to Indian citizens also, that ultimately the same order is going to be passed. There is what is use in passing this order. This is what in corporations, Unauthorized Occupants Act, so many acts are being, but definitely they are going to evict them. Then where is the question of rearing, giving an opportunity? All this may play vital role. Therefore, go through the judgment, keep the judgment on your file and record. Be armed with the entirety of the other judgment which I have referred and read, 1955 and 1991, and these two things are 1989 judgment, and be very careful how to dissent with the judgments, pursue the judge who is not inclined to extend the principle of natural justice. It's all right. What else? What next? Next is I want to share with you that these corporation authorities, metro sewerage authorities are engaging private contract employees, and they are not at all working. This is nothing but seems to be a scam. They are simply assembled and paid, and whenever they are stationed to work, I don't think their physical appearance seems to be in working capacity of these natures. What is happening? There should be some check. Otherwise, the muster roll scam is reminding me. So I hope some socially interested persons may concentrate on this issue of private contractors claiming to have been applied, and particularly during rain seasons to clear the road. But I noticed in some places really some persons are working hardly. But so far my experience is concerned in my particular ward, and the employees who are engaged on contract basis are not working at all, and instead they are being used as goons and threatening the public, including the ruling party member, claiming that they are also party men, and nobody should question. They simply come, stand, have their snacks and tea, and simply clear the places, leaving the whatever the ugly scenario which has to be cleared up. This is the way the corporation authorities and metro sewerage department is working. And I could not understand these sorts of when there are heavy unemployed persons are there, particularly these works are being allotted for poor downtrodden people. Why this corporation or metro sewerage department is not engaging at least on flat rate basis, instead of engaging private contractors in the naam ke vaste, they like fabricating muster rule. I want that somebody should concentrate on this issue, so that this should be immediately checked. Otherwise, a huge amount of taxes may be wasted and siphoned for money laundering persons, and at the cost of these hooligans who is claiming to be contract laborers. Practically they are not. This is what happening. The problem is this Washermanpet area was a town even before the British people arrived. Only because this Washermanpet seems to be a somewhat civilized town. The British government purchased it from the Sultan who is control of this Wassermanpet area. But this area is now being neglected for years together by hard-hand criminals who are running contract with the departments. Best wishes.